appear on the record.
Good morning. The court is calling case number D530134. This is Ryan Giraldo versus Andrea Gutierrez. I see that the parties are present. I don't have video appearances by either of you. If you want the court to, if you intended to appear by video, you need to turn on your camera. Okay, I can do it just with you appearing over the telephone. There you go. Thank you, Mr. Giraldo. Ms. Gutierrez? Okay. Ms. Gutierrez, I need you to unmute yourself, though, because I do need to have the two of you sworn in. If you could both raise your right hand, and you need to unmute yourself so I can hear you respond, Ms. Gutierrez.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ms. Gutierrez, I don't know that I even have you there, so I need you to make your appearance known, please. Ms. Clerk, any idea?
We're going to go ahead and try to reach out to her, Judge.
Matter of Giraldo versus Gutierrez. Ms. Gutierrez, are you attempting to appear by video or just by telephone?
Just by telephone, yeah.
Okay. Well, I need you sworn in. The other party was already sworn in. Please raise your right hand and answer verbally when you've been given the oath.
You got it.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, thank you. So this matter is on initially for 2 motions for order to show cause filed by Mom. In the interim, there were oppositions and counter motions filed by Dad. Frankly, and I'm sure Judge Gentile has made this observation, the voluminous filings make it very difficult to keep track of even what the court is supposed to be addressing at any given time. And neither of you are doing yourselves a favor under those circumstances. I'm going to set some ground rules in your case. This is our first time dealing with one another. And you all need to understand the court's expectations so we can move forward from this point. There are a very limited number of things this court is authorized by rules to do ex parte or will do ex parte. I can extend time, shorten time, issue orders to show cause regarding contempt, and continue hearings. But given the history of this case and the overwhelming amount of litigation, nothing will be done ex parte in this case. So please no longer submit ex parte requests for relief, sir. Secondly, there are page limits and type volume limits set forth in 8th Judicial District Court Rule 5.504 subsection E, and the parties need to abide by it. If you need a copy of it, my assistant can send it to you, but you're representing yourselves and you're expected to know what the rules require as far as your pleadings. If you submit a document, for example, with more than 1,300 single-spaced lines of text, it is not a valid submission. The court will strike pleadings that exceed this limit going forward, as I'm permitted to do by the rules. I don't need a recitation of the entire case, and I certainly don't need a rant berating the court for its prior orders and continuing to degrade one another with respect to your behaviors in this case. Both of you have behaved deplorably. Judge Gentile has made very clear orders. That's what this court is bound by. That's what the two of you are bound by. Whether it's me or any other judge reviewing this case, the findings leading to the current orders and the orders themselves control the current circumstances. In that regard, Judge Gentile also gave very clear directives regarding when and under what circumstances modifications to the existing orders will be considered. And that is true whether it's a request to expand contact with the child or request, yet again, supervised visitation for the mother. The court made clear orders. If you are confused, see the minute order December 11th, 2020. The current order states, Mom has unsupervised visitation every Saturday from 10 to 6. Dad or his wife are to provide the transportation. This decision was made on full information by Judge Gentili and was not appealed by either party. That's the recourse if you think the court has made a mistake. You file an appeal and have another higher court review it. The current request, Mom asked to clarify whether the April 20th order included ongoing compliance with the previous holiday order. It did not, and it will not. And to be clear, all of Dad's references to 432B are inapplicable. That is not the law that governs this case, sir. It's Chapter 125. It's the custody statute. 432B applies to when the state is involved in instances of abuse and neglect and the child has become a ward of the state. Hopefully we never get to that point. So with regard to the order to show cause for missed visits, because the missed visits are primarily concerned with holiday visits, the court does not find that there's a basis to consider further contempt. Are you clear, Ms. Gutierrez, that there is no holiday visitation? Your visitation consists entirely of Saturday from 10 to 6.
I do understand.
Okay. Sir, you were ordered on October 5th to submit to a hair and urine test, and there is no record at ATI of you submitting to that test. Did you? Yeah, I'm sorry, sir. You're muted. We do it all the time. Can you unmute yourself?
Yeah, can you? Okay. So I had my employer send over my test, and I thought that was going to be sufficient.
No, you raised that issue at the time of that last hearing where it was ordered that you submit to a hair and urine test. That is not sufficient. You are to go by 5 p.m. today. And to be perfectly clear, your failure to submit to the test is going to be considered a positive drug test. And then we'll deal with that. Is there any reason you can't go by 5 p.m. today?
No.
Okay. That's the expectation. And again, the presumption will be that it's a positive test if you fail to comply with that order. That is the order that's been violated. The court's looked through the remaining of it and is not going to, as I stated, pursue contempt. All other requests are denied. I do believe that there was an intention of Judge Gentili to order child support, again, with the voluminous and multiple filings, things like that. Very important things get lost, right? When you're trying to review 10 different documents asking for 10 different things. So if the parties are still asking the court to consider child support, and under the circumstances, it's certainly warranted. I wouldn't fault anybody for requesting a review of child support. I need updated financial disclosure forms, particularly now that you're working, sir. Have you received your first paycheck yet? Directed to you, sir. I'm sorry. We lost you for a minute.
Okay.
Did you receive your first paycheck yet?
Yes.
Okay. So provide updated financial disclosure forms, attach your most recent pay stubs. I'm setting this on what's called a chambers calendar. You've dealt with those before. The court is going to review the results of the drug test and review each party's financial disclosure forms, and the order that will result will address those two things. My intention is to avoid any further proceedings. If the drug test is negative, then there isn't a need. to have further proceedings, and I will just issue an order that acknowledges that and makes an award of child support if warranted. The date for the Chamber's calendar will be April 16th at 1:05 a.m. That's how you know you don't need to be here, because I won't be here. And I believe that addresses everything today. Thank you both. All I have.
You, Your Honor.
Thank you.
And we are on the record.
All right. So good afternoon. This is case D530134, Ryan Giraldo versus Andrea Gutierrez. I see Mr. Giraldo there. I don't see you, Ms. Gutierrez. I see that you are there telephonically. Do you have the ability to turn on your video?
I'm here, Your Honor.
Okay. Are you there by video?
Let me see. Does it work? Hello?
Yeah, there you are. Thank you. All right. So the court set this hearing by minute order. There were instructions at the last hearing regarding submission of drug tests, submission to drug tests at ATI. As a result of those drug test results, the court made further orders. There was an indication from Mr. Giraldo that you were unclear on what the court expected. So I wanted to have this hearing in person so you could be clear on exactly what the court was looking for. Okay, sir? You, I believe, are telling the court that the reason your drug tests were positive was because you have prescription medication for those drugs. Is that right?
Yes, I had a prescription.
Okay. So what the court is looking for is for you to provide proof of that.
My treating physician said that any records you have that the court needs to ask for them. Because I tried to get them from him, and when he said that the court needs to ask for them.
Well, except I would assume that you have prescriptions in a bottle, right?
Yeah, I turned that into ATI.
Okay. I'm asking you to turn it into the court.
Yeah, I don't have any more. I don't have them anymore.
Why not?
Threw them away.
Why?
They're empty.
Okay. When do you get more?
I don't get it anymore.
Why not?
It was a dentist appointment. I just had a root canal.
Okay. So it was a dental prescription?
Yeah, that's what I got.
Okay. So if the court was going to request the records, what was the name of the dentist?
I guess. Oh, it's Coast Dental.
Okay. Where?
On Windmill and Pecos.
And when was the procedure?
February.
So part of the problem with that, sir, is that you submitted to both urine and hair testing in April, mid-April.
Yeah.
You were positive in both your hair and your urine in mid-April. A urine test that's positive for both oxycodone and hydrocodone and opioids suggest that you use those medications recently.
Right.
And when you're positive in your hair for those medications, it suggests that there's ongoing use of those medications. If you were using them for a root canal, there shouldn't have been ongoing use, nor should there have been recent use 2.5 months later, right?
I see what you're saying, yeah.
Okay. So do you understand what concerns the court might have?
Yes, ma'am.
Okay. And the reason the drug test was ordered even to begin with was because the court had concerns about some of the behaviors you were exhibiting. I believed that some of the behaviors you were exhibiting were consistent with somebody who was probably abusing drugs.
No, that's incorrect. It's been Andrea Gutierrez, the defendant. She's always been, since she violated HIPAA law in 2016, she's always been, always trying to accuse me of abusing heroin, which there was no heroin in my system. And then
She didn't accuse you of anything. I made the accusation. She didn't raise it. She didn't allege anything. And my concern is not violation of HIPAA laws. My concern is your behavior led the court to believe that there might be some sort of substance abuse going on. Given your child's medical issues that you have advocated so strongly about, and have insisted that mom is incapable of meeting those needs, the court would understandably be concerned if you are abusing opioids while you are responsible for his care.
Your Honor, when Gentili ordered the drug test was before you took over the court case. Andrea asked for the drug test in November, okay, and I agreed to it. It wasn't like Gentili just out of nowhere because of my actions or that I was doing anything that would cause suspicion that she wanted a drug test on her own. Andrea is the one that brought it up to Gentili, and then she said that she wanted us, Andrea wanted both of us to take a drug test, and that she was going to pay for it. But somehow in the order, it only said that I was to take a drug test. It didn't say nothing about Andrea taking a drug test or anything. And
I sent you for a drug test, sir. I made an order for a drug test in March of this year.
Right.
Me, not Judge Gentili.
That's where it came from. You said I didn't take
the order in March. I don't know the relevance of that. It doesn't matter. And I'm sorry you're confused about it. Fact remains that you alleged you have a prescription. You don't have an ongoing prescription. There was drug use level that is not supported by any valid or verifiable or authorized use of medication consistent with your drug test results. And I have concerns.
Okay, yes, I do have a doctor that I do see every 2 weeks for addiction problems that I had in the past, and I get randomly drug tested, and I have not had a dirty ever. And so I guess this is the first one, and a minor lapse.
So what are you going to do about it?
I see my doctor, and we're working on keeping me clean like I have been in the past 4 years.
You
5
were
years.
positive in your hair. Sir,
Excuse me?
you were positive in your hair. This was not a one-time lapse. I'm sending you for another drug test today. You need to go submit to that drug test by 5 p.m. That's within the next 2 hours. Is there any reason you can't do that?
I won't be able to pay for that. When this
Okay.
happens,
Go submit to the drug test. And when will you be able to pay for it?
I won't. Because Andrea said she offered to pay for them.
Sir?
Your Honor, I
when will
paid
you-
for it before.
I'm not. When will you be able to pay for it, sir?
I get drug. I can get drug tested tomorrow from my doctor because I see him tomorrow.
I'm sending you to be drug tested in the next 2 hours. Go submit to the drug test that you're being ordered to take in the next 2 hours, or the court will presume that you are still using drugs. When you can pay for it, they will release the results to the court. Tell me when you will be able to pay for it.
It's like $100 and something, Your Honor.
Okay, so when will you be able to pay for it?
Friday, I guess.
Okay.
I don't have a choice.
No, you don't
Is there a way
have
to
a
get
choice.
it waived, the fee waived?
No, I can't ask them to waive the fee. And according to your financial disclosure form, you make $23 an hour, right?
Yes, I am the sole provider of 5 kids. My wife.
Okay. Your financial disclosure form reflects that your wife contributes to the household. I have concerns. I mean, you've convinced the court that Ms. Gutierrez is a danger to your son. If you're using drugs that make you unsafe for your son, then I have a responsibility to notify authorities that your son is in danger. Go take a drug test.
Okay, that's fine, but that's not the case. She proved it over 5 years. That's what that's the difference, Your Honor.
Well, I'm not sure what you're saying, but I'll make that decision. Submit to the drug test, pay for it by Friday. I'm resetting the hearing for 2 weeks from now. We'll look at the results.
You're gonna want the records from Dr. Cruz?
Is that the addiction specialist that you see?
Yes.
I suggest that you provide the court with all medical records that are related to this issue.
He won't give them to me. The court has to request them from him. I think it's a medical something form.
They are your medical records. You can obtain your own medical records.
I asked him, and he said that he wants the court to send him a medical something form. I don't know why. But that's what he said.
And what specifically do you go see him for?
I get I'm prescribed Suboxone.
And you said that he drug tests you every 2 weeks?
Randomly.
And for 5 years this has gone on?
Since 2016, yeah.
And so for 5 years with random drug tests, you've never tested positive. The court sends you for one drug test. And I just happened to catch the one positive drug test.
It wasn't the one time. I went for CPS. I did a drug test for CPS and I don't know, I think it was 2018 or 2016. I don't know, 2018 I think it was.
Okay. And that was positive as well?
No.
So again, in 5 years, I'm sorry?
This is the first positive I've ever had. In 5 years. With multiple drug tests. For jobs, for CPS.
Interesting. Okay, so I'm being told you need to go to the ATI at 3340 Sunrise Avenue, Suite 105. That's the one that does. Okay. Kendall, Ms. Clerk, you understand which one he needs to go to?
Yes, Judge, I have the instructions for that one.
Okay. So those will be sent to you, and again, you need to attend by 5 today, and we will come back here on give me one moment.
The 27th at 2. Maybe.
11 o'clock on the 27th of July.
7, 27, 21, 11. Judge, you said 11 a.m.?
11 a.m. I know it's a CMC setting, but that looks like the best place for me to put it.
Nope, absolutely.
Okay. So you'll be provided that information shortly. And again, failure to appear will result in the court assuming the test would be positive. We'll come back on the 27th. We'll take a look at the results. You'll pay for it this Friday based upon your statements to the court. And we'll decide what needs to happen as a result of those test results. Okay?
Okay, so okay. Yes.
Thank you.
Is that it?
And we are on the record.
Hi there, good morning. This is D530134, Ryan Giraldo versus Andrea Gutierrez. Counsel, your appearance for the plaintiff, please.
This is Michael McLaughlin from ESO and Associates on behalf of Ryan Giraldo, phone number 12820.
Thank you. And Ms. Gutierrez, I can see that you're there. I don't see you by video. Can you appear? There you go. Thank you. All right, good morning. So this is on, the court set a status check following our last hearing. The court directed that the plaintiff submit to a follow-up drug test in light of representations he made regarding the results of his last drug test. My understanding, he is not going to be present today. Is that right, counsel?
Yes, Your Honor. If need be, he said he could try to be up here by phone, but he's on site at a construction site, and we probably wouldn't be able to hear him over the machinery.
Okay. So at the last hearing, as I stated, he was directed to submit to another test at ATI, hair and urine, confirmed with him that he would be able to submit by 5 p.m. that date, and he did not I believe the department received a call from ATI the following day, indicating that he appeared on the 14th, so the day after, and they were unable to have him submit to the test because it was later than the court had given him permission to. So, is there anything specific, counsel, that you want to make representations regarding on behalf of your client?
Well, Your Honor, I do know that I do have test results that he provided me from July 14th at 2:29 p.m.
Okay.
Urine toxology.
Okay, not hair.
No.
Okay. Why don't you tell me about those?
The urine toxology came back negative for everything except for BUP, which showed positive.
BUP?
And I apologize that yes, that's the abbreviation it gives for whatever that particular category is.
Okay, 1 second.
Sure.
Don't know what that is, and it wasn't on his last test.
And Your Honor, since I'm unfamiliar with this, if you'll indulge me, I'm just looking now in my files to see if there's anything else that he provided. Haven't. I could. I'm assuming.
I see what it is.
The court didn't get copies of it.
No.
Oh, I apologize for that.
So interesting. Ms. Gutierrez, this is important for you to understand. The court's not going to litigate this case for you. It's not appropriate for me to. My interest in obtaining drug test results for the plaintiff was an interest that extended as far as necessary to determine if a referral needed to be made to Child Protective Services. So you understand where the court is on this, Mr. McLaughlin.
Yes, Your Honor.
Court had already made findings that the defendant was an unsafe primary caregiver. These were findings that existed that predated me. That the defendant was an unsafe primary caregiver. The plaintiff was adamant in this, but there was behaviors by the plaintiff that were very concerning to the court and indicated to this court, based upon my years of experience doing child abuse and neglect for the Department of Family Services and doing domestic violence cases for the 8th Judicial District, that there was a drug problem. And we have a child that is identified by the plaintiff himself as a special needs child and requiring specific attention. And because of those concerns, the court directed that he submit to a drug test so I could ascertain whether there was a risk to the child. The drug test that he submitted to when the court directed that he submit to the test, when he had no indication that that was going to be requested by the court, was positive in both hair and urine at levels that suggested there was repeated and ongoing use. When he was confronted with that, his response was that it was consistent with medication that he takes. I asked him to provide proof of that from his physician. In other words, submit those prescriptions to the court. When he did not, I set the matter for a hearing. when I asked him under oath to be more specific about the medication that he is prescribed, he was evasive and ultimately said to the court that he has been on a medication intended to treat chronic opioid addiction, that he is to refrain from use of opioids while he is on this medication, which is contrary to the results received from his drug test, which showed, in fact, frequent and ongoing opioid use, and told the court that he, to get this drug to treat his opioid addiction, must submit to drug tests by his treating physician, and that they have never come back positive. This is his sworn testimony. I found that hard to believe. I asked him to explain then this test, and he said it was a slip, meaning his use of the opioids. I found it very hard and continue to find it very hard to believe that out of the 4 or 5 years he alleged that he's been treated for opioid addiction and has tested negative for his treating physician, we happen to get the one slip that he admitted to and caught that on our test. Which is why I asked him to submit to another test, and now what he is testing positive for is this drug, bupropion, which looks to be the drug that, in fact, treats his opioid addiction. So I continue to be concerned about his drug use. I can tell you that at the last proceeding, he was disoriented. His speech was somewhat incoherent and slurred. I'm not sure what to do. I continue to have concerns. I don't have any reason to believe that the defendant is any more appropriate to care for this child than he is. It's unfortunate that he's not here today. It's unfortunate that he didn't submit to the drug test when I asked him to. It's unfortunate he didn't provide a statement from his doctor or any other information that's been asked of him. It's not that the court isn't giving him opportunities. But again, this isn't my case, and all I can do is make the appropriate referral based on the information that I have. If there's anything you care to say on behalf of your client, you're welcome to. If there's nothing you need to say, I respect that as well. These are unusual proceedings.
Well, and Your Honor, if I may, and they are unusual, but I understand the court's concern. I'm not sure if another attorney was handling this on behalf of my client prior to, but if it would please the court and put the court's mind at ease, I would ask for a little bit of time to see if I can get the documentation from plaintiff's doctors, finding out that he is on this medication, that he will stay on this medication, how long he's been on this medication, if he's ever tested positive in the past for these doctors for any opiate use along with this, how often a positive may have come up. Understandable that if he's on this medication, he has had opioid problems in the past, and I'm sure that part of the court's concern is that he appears to not be being forthright with the court on his recovery. And I would like the opportunity to try to rectify that, at least as far as putting the court's mind at ease that he is being straightforward and honest with the court about his recovery and what his use is.
Again, there's nothing pending before the court. The underlying issue that brought this matter before the court was the defendant's motion to enforce her visitation rights. He filed a counter motion. Those issues have been resolved. will let you know. I'll let Ms. Gutierrez know. I'm going to go ahead and make the referral that I think I'm mandated to make based upon all the information that I have. Certainly there's going to be an opportunity for him to still respond to any concerns. If my concerns are unfounded, then the appropriate investigative agency is going to find that out for themselves. I don't know if his doctor knows about his positive drug test, but I don't think it's my place to involve myself in that. That's not the court's role. It's the role of an investigative agency who's charged with the responsibility of protecting children. So again, I'll make that referral, and I'll let them do what they need to do in the course of ensuring this child's safety. He's 14 years old, but for the fact that he has special needs, I might not have concerns, but he is, and so I'll let them decide how to handle it, okay?
Your Honor, may I say something?
Absolutely, Ms. Gutierrez.
Thank you. So my son is 14 now. His needs of prior, before aren't the same as they are now. He's grown out of his issues. The dad and, his wife took care of, all the doctor's appointments. I never said that they didn't. But he doesn't have this problem anymore. And he hasn't been to the doctor for it recently. But my son does specify to me every time he comes and sees me for the 8 hours on the one day that I get him, which is a weekend, that, he doesn't have any more issues. So I just want to make that known. And I'm not asking for full custody. I'm not trying to take him away. I just want my son more than 8 hours.
Well, but that's not what's before the court today. I mean, that issue was resolved. There's no motion pending before the court. You can file something else if you want the court to consider those issues. I've moved past that. I had concerns about the plaintiff. That's what I've moved on to address. Okay. So again, it's not for me anymore to look into. I needed to satisfy myself whether there was any safety issues, and I have ongoing concerns, and somebody else has to address them now.
Understandable. Thank you.
Okay. Thank you. Anything else, Mr. McLaughlin?
No, Your Honor.
Okay. Thank you. There's obviously no order necessary as a result of today's hearing. The case will be closed. As far as this court is concerned, that doesn't prevent you, Ms. Gutierrez, from filing further proceedings. It just means with respect to the motion that had brought the case or reopened the case, it's closed now. Thank you all.
Thank you. In respect of you, I didn't file anything because you told us not to at the time. So I am glad you gave me the clear to do so.
You're welcome.
Thank you.
Okay, thank you.
Thank you, Your Honor.
We are on the record, Judge.
All right, good morning. This is case D530134, Ryan Giraldo versus Andrea Gutierrez. Let me get counsel's appearance, please, for defendant.
Good morning, Your Honor. Megan Shigemitsu, bar number 14618 from Gandhi Dieter Blackham, on behalf of Andrea Alessa Gutierrez, the defendant in this case, who's appearing by separate Blue Jeans link, and she goes by Alessa.
Okay, thank you. And I have the plaintiff available as well. So this is back before the court on motion filed by mom to again consider modifications. This time the strategy is to ask for modification to visitation, reserving the right, whatever, frankly, I'm not sure what that means, but reserving the right to argue for a modification of custody. I suspect it's sort of a let's see how things are going, and then I'll decide if that's something that we're going to pursue. It is not true that the court does not need an evidentiary hearing and to modify visitation. I do. Gordon v. Geiger says that the court cannot make changes that impact the custodial parent's time in favor of the non-custodial parent without an evidentiary hearing. So whether it's a modification of visitation or a modification of custody, the only way these things get resolved is through an evidentiary proceeding. Utilizing the party's resources and the court's resources to have an evidentiary proceeding for visitation or even custody related to a 16-year-old, which he'll be in just a couple of months, seems like an extraordinary waste, I'll be perfectly honest with you. And more than the circumstances concerning your son, it is reflective of the party's ongoing inability to accept the circumstances that they find themselves in, take responsibility for the circumstances they find themselves in, and an unwillingness to extend any sort of grace whatsoever to the other party just by virtue of the fact that that other party is a parent to your 16-year-old son, along with other children that are no longer under this court's jurisdiction. This case frustrates me beyond belief. What the two of you have done to your children is inexcusable, and you're not going to stop. 16 years old, and you're not able to stop this. I am not concerned, counsel, with whose fault this is. They are both to blame. If you want an evidentiary hearing, I'll give it to you. Dad tested positive for drugs. Mom's raising that again as a basis to modify custody. It's not. I was satisfied with the information given at the last proceeding regarding the drug use. I confirmed again for my own information today, based upon ATI guidelines, that his drug use is consistent with prescription drug use. I will order him drug tested again today so that we can confirm his levels are consistent with prior drug use or prior prescribed drug use. And he'll have to supply the prescription drugs to ATI when he goes there. I'll give you a deadline, sir, of when you need to submit today. I guess what ultimately frustrates me most of all is that whether I grant an evidentiary proceeding and these parties spend the time, money, court's resources to conduct an evidentiary hearing, or I just deny it outright today, I haven't heard the end of it. There's still 2 more years, and I suspect both of them will find plenty of reason to refile motions in front of this court, whether they have any value or merit, or whether they are in the best interest of their son or not. And if either one of you thinks that this speech is directed at the other party and not to them, you're wrong. This disdain for how the parties have conducted themselves over the lifetime of their litigation extends equally to both of them. Period. So, counsel, I'm not making any changes today, not one. If your client wants to pursue an evidentiary proceeding, I will set a discovery schedule and we'll go to trial. The child will probably be close to 17 by the time that happens, but we can keep fighting.
Your Honor, since I was not, I have reviewed the case history extensively coming onto this case. I was just retained when I filed the underlying motion. But I think it would help for clarity purposes because I'm confused about the position of the court because there was a situation in 2018 and 2019 regarding Alessio's health and into 2020, and there was statements in the orders that he would be with Dad primarily for a basis to get his gastrointestinal issues and diet and with consistency, and it was right in the order that it was presumed about 6 months out if he stabilized and he would be older and more mature and able to articulate his needs, that Mom would then be able to possibly have additional visitation. She did come before the court unrepresented prior to retaining counsel with our office, and she filed a motion to modify to seek sole legal and sole physical custody, which was denied outright by the court. So that's the basis for the underlying motion, is that I felt as an unrepresented party, she had asked for something that was not tenable and it was not properly pleaded. But it seems clear to me from the court record that once Alicio became more stabilized, that it was anticipated that it would be considered that mom would have more than 1 day a week of visitation. They used to have joint physical custody. I understand there's a very complicated and long and litigious approach to this case by both of them, though certainly in recent, for this underlying motion practice, I feel the requests have been reasonable, the concerns have been well substantiated, and Mr. Giraldo has filed numerous unmerited repeat motions, which we have not. I did file a motion to strike the first 1 or 2 of them, and then he kept filing them. So I don't think that they're been the same with their approach, at least in the recent actions. But that's really where we're coming from, is we're just trying to get some temporary visitation so that she would have more than just 1 day a week with her son, especially because he is turning 16 next month, Your Honor, well, in November 1st, I believe. And, you know, Ms. Gutierrez has tried repeatedly to have just additional visitation with him, and she has not been able to get Mr. Giraldo, which is, I think, evident from the way he handles this case, the pleadings he has filed, their social media posts. It is quite clear that he is alienating Ms. Gutierrez and not making any efforts to allow her additional time with Alicio.
Well, first of all, the only exhibit related to their communication asking for additional time out of the 108 pages or more that the court reviewed that were submitted by mom, there is one text message. She says, hey, I want extra time. He says, no, we're sticking to the order. Him insisting that they abide by the order, especially in a contentious case like this, is not problematic for the court. There is substantial evidence of mom's ongoing alienation of the children from their father. She speaks negatively about him. She has nothing to say that's positive. The children have tried to stop her from talking to them about their dad. Again, this goes both ways. I am not blaming one more than the other, but it is also not true that your client is blameless in this situation. This has been a litigated case. You've acknowledged that. There were substantial findings made, and I'm going back. I mean, this case started, I have to go through pages and pages and pages of court summary. There are 58 pages for a case that started in 2015. 58 pages of litigation between these parties. And they are not 1 inch closer to being able to deal with each other respectfully. That's where the frustration comes from, counsel. I've only been on this case for 1.5 years and have already had way too much of these parties. And the parties learning how to deal with one another. I mean, it's hopeless at this point, to be honest with you. And once I get to the end of the 58 pages, I will tell you when the court addressed the concerns that you're raising right now. In March of 2021, the court responded to those concerns and increased mom's visitation, consistent with the order that was made by Judge Gentili, acknowledging that their son was not at risk the way that he was initially, and that Judge Gentili anticipated an expansion of mom's visitation. The court did so to the extent that was appropriate at that time. So it's not that mom, as an unrepresented party, has come before this court and the court's ignored her concerns. I've addressed them. I've addressed dad's drug use. I've addressed these parties the same way I'm doing today at prior hearings, letting them know that this is unproductive.
I understand, Your Honor, but there was subsequent orders from April of 2021 and July of 2021 when Mr. Giraldo tested positive for drugs, morphine, oxycodone, and hydrocodone. The court asked him to provide proof of his prescriptions, and he did not. And then in July 27th of 2021, Ryan did not appear for his drug testing and then tested for BUP the next day, and the court noted that it was this was used to treat his opiate addiction, but that it still had concerns about the levels and his history and use of drugs, and advised that it was inclined to refer the case to CPS. That's the court records that I reviewed. I don't know what happened with the referral to CPS, and it was also stated in that July 2021, so that's that's after the order you just mentioned, Your Honor, that mom was self-represented and the court told her to file a motion, and that's when she went forward and filed the motion in January of 2022, which was for sole legal and sole physical, which I fully acknowledge was not legally the right request, and she didn't have any counsel back then. So, but it certainly seems to me like there's been cause for concern since March of 2021 that merited wanting to revisit this, and and she's only seeing her son 1 day a week with no overnights. So she has extremely restricted visitation, and meanwhile, in Mr. Giraldo's own filings and the motions that he filed for the court that he thinks is supportive of showing that he's a good parent, there's adult diapers with feces that he and his wife are posting on social media. It's really despicable behavior, and by no means, Your Honor, am I saying that my client is blameless. I have done due diligence of trying to get caught up in reviewing this very extensive case, and I agree with you 100% that this is an obscene amount of litigation, and there's concerning behaviors throughout the case by both parties. But I just feel that there's very concerning behavior by Mr. Giraldo with how he's handling himself on social media, just how he's approached his pleadings. He seems very unstable, and the drug use. And so I just feel 1 day a week with Ms. Gutierrez is quite low. And so that's what brought us before the court here. And Alicio we can proceed with evidentiary hearing. I was really pushing to have some additional visitation with Ms. Gutierrez under the circumstances, with Alicio turning 16. I don't know the last time I haven't seen anything in the last few years of this case, and I believe this was when Judge Gentili was the judge on the case, but Molly Rosenblum was appointed as guardian ad litem, and that was back in 2018, and there are notes in the 2018 proceedings from, I believe, October 29th, that Alicio said he wanted to spend more time with his mom and actually preferred being with his mother during the weekdays and his dad on the weekend. And then we've had the additional information come forward of DACs of their adult daughter, indicating that there's a lot of drug use and alcohol abuse by both Mr. Giraldo and his wife, and physical acts against the children. So that's really where we're coming from. I just feel that a day a week seems extremely low for visitation with mom, given both parties' behaviors in this case.
Mr. Giraldo, what's the problem? Why shouldn't she have more contact? Don't argue your motion. Answer my question. Your motion is filled, and your exhibits are filled with things from 2018. I'm not interested. Tell me today, given your son's circumstances, why it's not in his best interest to spend more time with his mother.
Well, she doesn't leave the kids out of the litigation. Like, all I really wanted to do was co-parent, and
that, sir, is a bald-faced lie. That is a lie. You have never tried to co-parent. This case has 58 pages of litigation, and that's just the title of your documents. Understand, when I'm referring to the amount of litigation, I have 58 pages telling me just the name of the documents that have been filed in this case. Do not suggest that you have attempted to co-parent with her. Tell me why it is not in your son's best interest to spend more time with his mother.
Okay. Well, the reason why we're here is because she had my daughter lie on her affidavit. That's why she tried.
We're here because you two have a complete inability to put your children first. Answer my question, not the one that you want to answer. Why isn't it in your son's best interest at almost 16 years old to spend more time with his other parent?
Number one, she He's on a strict diet still. He's on a strict diet still.
He's also 16 years old.
He's on a strict diet right now. He's in the best condition that he's been. Like, he's like very happy. He's very stable. He's getting good grades. He's playing on the football team. We work out together. I have a home gym in my garage. He's very stable. He's very happy. He gets home cooked meals. He takes his medication every day. He drinks only water. He's very stable and consistent. When he goes on Saturdays, it's like his cheat day, which I don't approve of, but there's nothing I can really do when he's not with me for 8 hours. I encourage him to stick to his diet, and I tell him it's not a cheat day. You still got to follow everything, but it's clear and undeniable that they go out to buffets every time they post it.
There's nothing about that that's clear. You show me where that is clear, and I'll consider that argument. There is nothing about what you've represented or presented to the court about the current circumstances that make what you are alleging clear.
In Aliana's affidavit, it states that he is able to eat whatever he wants now. That's not true.
Okay. Well, if your son at 16 years old doesn't know that and is not capable of making his own decisions, then quite honestly, Ms. Gutierrez is the least of your problems, because he is in no position to emancipate to an adult if at 16 years old he doesn't understand the consequences of the choices he's making. And continuing, frankly, to prevent him from experiencing those consequences, you're not doing him any good. That, frankly, is not good parenting, in my opinion. There has to be a point in time where it becomes his responsibility, not yours, not his mother's. Right? If it's not 16, is it 17? And if it's not 17, is it 18? And if it's not 18, is he going to live with you for the rest of his life so you can continue to make choices about what he should and shouldn't put in his mouth?
What I know is that it's the court's responsibility to make sure that he's safe, and due to the, circumstances surrounding this case, I mean, how can, I've done everything in the best interest of my child's health. Right now, he's stable because he's been with me primarily.
I don't know that. We don't have anything to compare it to.
Oh, yeah, this has already been proven in Judge Gentile's court, through Judge Gentile. This is on record.
He was 14 years old or 12 years old. Understand what the court is telling you, sir. Your position is unreasonable. The fact that you won't even consider that is unreasonable. At 16 years old, the fact that you think maintaining this level of control over your son, health issues or no health issues, is unreasonable. There is no way he will be a successful adult if you think the only way to keep him healthy is for you to monitor every single thing that goes into his mouth, and that nobody else is capable of that function. Are you on medication currently, right this minute as we speak, because the court's making a note on the record that you are slurring your words?
That's incorrect, Your Honor.
I'm asking you. You didn't answer my question.
Test right now. I will leave and take a drug test right now.
How quickly can you go to ATI?
On me completing a drug test negative, then this cannot go on anymore. Okay?
Yes, it can.
Jonah has proven over 4 years, for a treatable condition. This was not a hereditary condition. Unjustifiable pain and suffering. Because okay.
I don't know, sir, I don't know how you expect your son to have a relationship with her, a positive one that has a positive impact on his life, if you refuse to let it happen. The court is making temporary orders today that mom will have Saturday to Sunday overnight every week. Dad is to submit to ATI today. When can you attend ATI? Give me a deadline.
I object, Your Honor.
I understand. I'm not listening to your objection, sir. I've read everything. I don't need to continue to allow you to argue the same things. I'm asking for a reasonable response to my questions. I'm not getting it. Tell me when you can submit to your drug test at ATI.
Right now.
Actually, I'm not going to take time out of my work day. I'll go take a drug test when I get out of work.
When is that?
I get out of work at 2:30.
Okay. So at 3 o'clock.
There's no, Your Honor, hold on, please, 1 second. I need to
Negative
speak.
drug test.
I submitted a negative drug test.
Can we, is there someone else present? Can we have that on the record of who else is speaking?
Who else is in there, sir?
Your Honor,
Who's in the car with you?
my wife is in the car with me. My wife of 9 years is in the car with me. She had to bring the computer so that I can do this while I'm at work.
She doesn't need to sit in the car with you.
Mm,
Tell me
no.
what time. If you get off of work at 2:30, when can you be at ATI?
Before it closes?
I need a specific time.
Okay, Your Honor,
Alicio said he didn't want.
Listen to me. Your wife needs to step
I'm
out of the car.
listening to you.
She's not participating in this hearing. She needs to get out.
Emotional trauma. Tell us what Alicio said. She told him that the case was reopened. She told him that.
Yeah, so...
Answer my question. Don't tell me what you want to tell me. I've asked you a specific time. You will go to ATI today.
Before it closes, I have a company truck. I have to drop it off at the office. Then I have to get picked up and go to ATI.
So when is that going to
besides that-
happen? That's what I'm asking you.
Before it closes, Your Honor.
When does it close, sir?
I'm assuming 5. I'll have to Google it and check.
Okay. You'll be there at 4:30.
As long
That's
as I
the
can
deadline
make sure,
to submit to urine and hair test. Mom's overnight visitation will start this weekend.
No, Your Honor.
And the court is
Your
going
Honor.
to interview your son.
Good.
What do you, Your Honor? This is going. You have. I don't know if you know. Like, well, obviously you don't know everything that's gone on. Okay, so how does the mom get to abduct? Number one, abduct my children, which is a category D felony. Number two, withhold.
She's still
my children.
talking to you.
Your Honor.
You are disregarding the court's directives, sir. I understand your arguments. I've asked your wife to leave the car. She's still
She's out of the
talking
car.
to you. Where is she talking to you from?
She's out of the car.
Out of the car, close the door, stop participating in the proceedings.
Okay.
I don't want to hear
Can I
her.
finish talking? No.
If we were in court, sir, she wouldn't be talking to you. This is a proceeding that's going to happen in court going forward so that I have cooperation from you. I'm not listening to your arguments. I've made my order. You will
You can
submit
listen to a whole argument, but you can't listen to mine?
I'm not listening
How
to
is that
any of
even
these
fair?
arguments.
I have
sole custody, not sole, but primary custody for a reason. She only has 8 hours for a reason, Your Honor. So you cannot just go and make and change. Just like you said, you need to have
I'm making a temporary order.
hearing.
Listen to me.
Your Honor,
Stop talking over me. Future proceedings will be in person in this matter, period. I'm not going to have this argument with you. Future proceedings will be in person. I've made my orders. I'm making a temporary order pending evidentiary hearing that expands mom's visitation to something that is patently reasonable for a 16-year-old, even one with your son's health issues and the history in this case, of which I am very familiar. You will receive an emailed referral to submit to hair and urine testing at ATI by 4:30 p.m. Your failure to do so will presume or lead the court to presume that the test would be positive. The court is ordering the child to be interviewed. I'm setting a return hearing date on that interview, and from there, we will set further proceedings.
Your Honor, I'm not done talking, Your Honor.
Sir, I'm not listening to anybody.
You heard counsel speak, and you let her say everything she needed to say, so I need to speak and say everything that I need to say.
You have 3 minutes.
And you need to listen, Your Honor.
Excuse me,
You did not give her a time limit. You did not give her a time limit. How are you going to give me 3 minutes?
Because I didn't let her talk indefinitely either. I'm not having this argument. End of proceeding. I'm not having this argument. Prepare an order,
We just need
please, counsel.
Yes, I just want, before we go off the record, to make sure we have times for the exchanges and who's responsible for transport and location.
I'm also sending the parties to FMC. Mediate. As fruitless as I believe that may be, hopefully the parties understand. What time is your client asking for the exchange?
I believe
She gets them what time on Saturday?
What time, Ms. Gutierrez, is 8 a.m. or 9 a.m. okay?
9 a.m. works fine.
How do you get him now?
I pick him up. The order does state, though, that the other party's supposed to pick up and drop off, but I just figured it would be easier for me to go ahead and pick him up and drop him off.
What time do you pick him up currently?
10 o'clock.
You'll pick him up at 10 o'clock, and you will return him Sunday at 3 o'clock.
Thank you, Your Honor.
Thank you, Your
The
Honor.
parties will go to FMC, the child will be interviewed, we will come back, the court will receive dad's drug test results. If a minute order needs to be issued as a result of those drug test results, then the court will issue a minute order. Let me get a return hearing date, please, on the child interview.
Judge, I have November 29th at 2:30.
Hang on, Madam Clerk, I'm checking that schedule.
I can go before then.
That's the
No,
two.
I just wanted to be sure. I wanted to see where it was relative to the holiday. I wanted to be sure that this court would be the one hearing the case. That will be for the return from FMC. Again, the parties will be referred there to mediate. Any questions about the court's temporary order for visitation?
No, only a question about the return hearing. Is that to be in person, Your Honor?
All hearings going forward will be in person.
Okay, thank you, Your Honor. Oh, and you would like me to prepare an order for today?
Please prepare an order resulting from today's hearing. The referrals to FMC and dad's drug test referral will be emailed to both parties.
Your Honor, no further
Thank
questions.
you.